Hi, everyone. Can you hear me? Ellie, can you hear me?
Yes.
Okay, great. Okay, so thanks everybody for joining. Why don't we just dive right into the Corporate Transparency Act. There have been some new updates since last time we've done this, and let's do it. Okay, so today's agenda. First, we'll talk about a little bit background and the purpose of the Corporate Transparency Act. We'll talk about which business need to file and any exemptions, who needs to be listed on the filing, what information is required and what the deadlines are. And lastly, we'll cover the federal court decisions and the future of the CTA to the best of our ability. So a little background. Let's start first with the terminology. First of all, the name of the law is called the Corporate Transparency Act. It was enacted in the year 2001. It only went into effect January 1st, 2024. It was just a small piece of a larger National Security Act. What the CTA requires you to file, the actual filing itself is called the Beneficial Ownership Information Report, the BOI, or some people call it the BOIR. And those are the people that the government wants to see who are actually the people behind the LLC, whether it's different standards that we'll see a little bit later on. And the one that controls it, sometimes we use the word IRS loosely, but it's not the IRS, it's FinCEN, it's the Financial Crimes Enforcement Network. They're the ones that have this database. They're the ones that you have to report to. So if you grew up in New York back in the day, I see this guy actually has a mask, so they must be still doing it today. There was always people on the side of the street playing the game called either 3-Cup Monte or the shell game, where they would have 3 cups and a little piece or a dice or something, and you had to bet on which one, that you can figure out which one the dice is under. Just to give you a little description of it, a little picture, here's what they would do. Well, this is the game that the federal government has to play with LLCs and all the shell companies that are hiding in it. You have companies and layers, holding companies and sister companies where they pass through, where they use to have money laundering, financing terror, corruption, and tax fraud. So the federal government is trying to control this, rein it in. Somebody even told me that the basis of the whole Corporate Transparency Act happened from 9/11 because they had a very hard time following the money trail to crack the case. So this is what the government's up against. This is what the government is trying to accomplish today. Now let's contrast that to the states. The states are willing to look the other way. As you know from LLCs, every state has its own laws. Many states will let you be anonymous. Some will give you better asset protection, but each state has their own reason. Each state gets to control the commerce in the state while the government controls interstate commerce. So the states have an agenda. It's not security, and therefore people leverage one state off the other to build themselves a structure that they can hide their money in. Whereas the government, they want to know everything about your LLC because they're not interested in playing these games. They need to know all the details. So we have to figure out which businesses need to file the BOI and which are exempt. In general, the target of the Corporate Transparency Act was against the small companies. Therefore, it's only state-filed companies. Any entity that's created by filing with the Secretary of State, those are companies that have to file the BOIR. So that would include corporations, LLCs, LPs, foreign companies registered in the United States. It wouldn't include sole proprietorships because those you can open by yourself. You don't have to file with the state. And it doesn't include a general partnership if you want to open up a business with a partner. And most trusts, there are a lot of sophisticated trusts out there. Some of them have to be filed with the states, but the typical trust that we know about does not have to be filed with the state. Now, there are 23 exemptions listed in the law of companies that don't have to file their BOI. And these aren't really exemptions because all these companies are either reporting already to the Securities Exchange or the Federal Credit Union. They're already reporting to the government. They're bigger companies, they're sophisticated companies, and the government knows a lot more information about them, and they don't need the BOI information. That's really basic stuff compared to what these companies are already filing. So the Corporate Transparency Act was really targeting the smaller companies, which was one of the complaints in the court case, which we'll get to. So it targets the small companies. And the actual companies, here's a list of the 23 exemptions. As you'll see, most of them are investment companies or securities or institutions. The ones that we're going to focus on today, because they're not regulated companies, are number 21, which is large operating companies, and number 3, which are inactive companies. So we have inactive entities. Now, many people have called me up and said, Tzvi, my company's inactive. Do I have to file the BOI? And the answer is, in most cases, you do have to file the BOI, even if it's inactive, because the government has their own definitions of what inactive entity means. And it has to meet all 6 conditions. The first condition is that it has to have been in existence since before January 1st, 2020. So it's got to be at least 4 years old. The second one is that it's not actively engaged in business today. It's not owned by a foreign person. Anything that has a foreign owner in it, whether it's active or inactive, has to file, even if it's directly or indirectly, even if it's a partial owner. Any foreign person who has any part of a LLC, that LLC has to file a BOI. The entity hasn't had any change in ownership in the past 12 months. There has not been $1,000 sent or received from the LLC's bank account in the past 12 months. And lastly, the entity doesn't have any kind of assets. It's not holding any assets today. So if you pass all these conditions, which very few companies can pass, then you are not considered an active company and you're exempt from your BOI. Otherwise, you have to file it. The other exception that we wanted to talk about is a large operating company. Any large operating company is real. It's not something that anybody's hiding behind. It has accounting, and therefore the government is not targeting them. So to be considered a large operating company, you need 20 full-time employees that are employed in the United States. You need $5 million in gross sales last year. You need a physical office within the United States. So here's where it gets a little tricky. You may have a holding company that has 2 daughter companies, and between them they have 20 full-time employees and they have $5 million in revenue. And you may have more sophisticated structures than that. So the rule is as follows. When it comes to the 20 full-time employees, any entity, it doesn't make a difference how big the parent company is. It doesn't make a difference how many sister companies are. Any entity, any LLC that does not have 20 full-time employees must file a BOI, period. The second part of the equation is the $5 million in gross sales. So the $5 million in gross sales can be consolidated. If you have a consolidated tax return, so all members of the group are considered to have $5 million in gross sales. And therefore, if it has 20 full-time employees, it would be exempt. So let's take a very basic example where you have a holding company that has company A and B, which are subsidiaries. Company A has 20 employees. Company B has $5 million in revenue. Which company do you think has to, of these 3 companies, which company has to file BOI? Think about it for a second. The answer is that only company A would be exempt. The holding company has $5 million in gross revenues because it has a consolidated return, but it doesn't have 20 full-time employees. Same thing with company B that has $5 million, that's actually generating $5 million in gross sales. They don't have 20 full-time employees. Company A, which has 20 full-time employees but doesn't have any sales, is going to be exempt because the $5 million in gross sales from company B would exempt them, would help them realize this provision. Okay, until now, are there any questions? Ellie? Okay, if there are no questions. Okay, we'll continue. You can chat your questions, and Ellie will stop me we'll stop at the end of each section, and Ellie will ask me the questions. So those are the companies that have to report, have to file the BOI. Question is, who needs to be reported on the BOI? Which people have to write themselves down? So the reporting people are three types of people. They're beneficial owners, and they cross a certain threshold of ownership interest. It's somebody who has substantial control over the entity, and those are directors and decision makers, we'll see. And then there's something called a company applicant, which we'll get into as well. The beneficial owner, to become a beneficial owner, you can either, it's the larger, it's either or. You could either have 25% of the total voting rights or 25% of total ownership interest. Now, things can get complicated when you have different classes of shares in an LLC, because LLCs allow you to have different classes of shares. So it's hard to figure out sometimes what the total ownership is or what the voting rights are when you look at the LLC as a whole. And if you cannot make that determination, then the federal government simply says, no problem. Anybody who has 25% of any class of shares, just make sure you list them on the BOI. Now, when it comes to ownership interest, the question is, what does ownership interest mean? So that's a very, very loose term and includes almost everything. If you have stock or equity interest, obviously, if you have voting rights, if you have futures or convertible shares, even if you haven't converted them into 25% ownership rights, then you must file. So you can have technically lots of people that are beneficial owners based on ownership right, even though if you broke it down, you can only really have maximum of 4 that own 25%, but you can have as many convertible shares as, other people, outside people with convertible shares, people with puts, calls, options, and that would give them as well if it equals 25% of the equity. And so you see that the government is really making this, it's casting a very wide net on the people that have to be listed. What about substantial control? What does it mean, substantial control of the entity? So substantial control includes anybody who's a senior officer. If you are in the C-suite, CFO, CEO, COO, CMO, anybody with a C in front of his name, he's got to be listed on the BOI. And it also includes general counsel. Anybody who has authority to appoint or remove officers or a majority of directors is also considered substantial control, because that means that person controls the officers, or even if it's a majority of directors can control the officers. So if that person controls a majority of the directors, that means that that person has control of the officers themselves. Now, the government here is very vague, and it has a few catch-all provisions. One of them is important decision maker. So it doesn't have to be C-suite, but anybody who can control either revenues or finances or processes, any important part of the company hierarchy would have to be listed as well. And then, just for good measure, if it hasn't been vague enough and wide enough, the law throws in the term any other form of substantial control. What that could be, nobody's figured that out yet, but it's out there. The third type of people that we said have to file the BOI are called company applicants. Now, a company applicant is anybody who actually forms the entity, which means that if an attorney or a CPA form an entity today, they will be in the FinCEN database as the company applicant. The FinCEN wants to know who to come after. They want to be able to do investigations. They want to know everybody who was there from the inception. So any person who actually forms the entity is going to have to list themselves as a company applicant with all the information that everybody else has. Not only that, but the person who directs the formation. So technically, you can have 2 company applicants on a BOI. The first one will be the person who's in charge of forming the entity. And the second one will be the person who actually pushes the button or writes it in or mails it to the Secretary of State. They would also have, both those people would have to be company applicants. Now, because anybody who's worried that they formed entities in the past, and all, as we said, all existing LLCs need to file the BOI, you're probably thinking, oh my goodness, that means I'm going to have to be on so many BOIs that I don't want to be on. Well, the good news is that the government understood that, and companies that were formed before January 1st, before the law went into effect, they're exempt from reporting the company applicants. So no, there are no company applicants for old LLCs, only for LLCs this year and going forward. So let's look at one simple case and one more complex case and figure out who needs to file. So take a look at this and tell me what you think. So we have a reporting company on top, and it has two individuals. One's individual A and individual B. They each own 50% membership, and then there's a manager, which is individual C. Question of who needs to be on the BOI, this is pretty simple. Everybody here needs to be on the BOI. A and B because they have 50% membership units. C because he's a manager. And A has to be on it also, even if he wasn't owning 50% because he's a manager. He has two reasons to be on the BOI. Now, it's important to know that when you put BOI people on the form, when you file it, you do not have to say what their role in the company is. You don't have to say if they're substantial owners or they are decision makers. The only thing you break out are whether they're beneficial owners, which encompasses both those categories, or if they're company applicants. Okay, so here the plot thickens a little bit and it gets a little bit more complicated. Let's say, and you have a structure where LLCs own two LLCs, own one LLC, and then there are individuals that own the two parents of the subsidiary LLC. Now, all three of these LLCs actually have to file, but each one has to be looked at on its own. So the child that belongs to the two parents, we have to figure out who's going to file, who's going to be listed on their BOI. So the broad answer is that we have people on BOIs. We don't have companies. The two parent companies would not be listed on the BOI. It would be the people behind the LLCs, and we'll track it back. The government will make you track it back as many layers as you can, as there are, to get to all the people that have ownership interest in this child company, and anybody who is a decision maker in this child company, or anybody who ends up owning 25%, no matter how or where, if their total ownership is 25%, they will have to be listed on the child company's BOI report. So let's look at this case. We have a reporting company that's owned by company Y and company Z. Each one owned 50%. Now you'll see company Y is owned by A and B. Company Z has 4 owners, and then there's F, who directs decisions through the Board of Representation. So which one of these people have to be listed on the BOI? Let's take it one at a time. You'll notice individual A is a 30% owner of company Y and a 25% owner of company Z. So although through company Y, A does not own 25% of the reporting company, but together with his holdings through company Z, he has a 25% interest in the reporting company. So A is definitely in. He's got to be listed as a BOI. A also happens to be the CFO, so A would be listed as a BOI in any event because he's a CFO. B owns 70% of company Y, which means B owns more than 25% of the reporting company, so B's got to be listed. C does not own enough equity in the reporting company, but C is the CEO and president. D and E are out because they don't own enough of the reporting company and they're not decision makers. And F, although F doesn't own any part of the reporting company, F is going to have to be listed because F directs important decisions. What happens if a trust is a beneficial owner? So we said before that trusts themselves don't have to file because trusts are not created by the state. But what happens if a trust is a 50% owner in an LLC? So the trust would not be listed as the beneficial owner of the LLC. The people behind the trust would have to be listed. So the question is, who behind the trust, which members of the trust would have to be listed as the beneficial owner of the LLC that it owns? So the first person is the trustee, because if they have the authority to dispose the trust assets, so that means that they're a decision maker in the LLC. The second, and this is very vague, is the beneficiary who's sole permissible, who's the only one. It says he's a sole permissible recipient. Now, the question is, does he own 25% of the LLC? What happens if there are two beneficiaries? This is an area that Congress has been, the law is very, very vague, and people are having trouble figuring out what this means. The settlor of the trust, if the settlor retains the right to revoke the trust protector, because the trust protector has the right to replace the trustee, just like a director can replace officers. Any distribution advisor who can make distributions from the trust. And lastly, any investment advisor, which is the same responsibility as a distribution advisor. There are a number of people explicitly exempt from filing, from being on the BOI, and the first one is a future inheritor. Just because somebody is listed in a will as receiving the inheritance, then it doesn't make them a beneficiary in any way. It doesn't make them a beneficial owner of the LLC, and they don't have to be listed. If a minor owns the LLC, a minor does not have to be listed, but that's only on the condition that the minor's legal guardian is listed. So while the minor itself doesn't have to be listed, the legal guardian must be listed. And as soon as the minor reaches age of majority, then the BOI would have to be updated to replace the guardian with the minor, who now has to be listed on the BOI. Creditors. So a creditor, just because the creditor made a loan and gets payments from the LLC, it doesn't mean that the creditor has to be listed on the BOI. If the creditor has collateral or has ownership in the LLC, then the creditor may have to be listed. If the creditor has enough conditions in the loan that they're considered a decision maker in the LLC based on those conditions, then the creditor may have to be listed on the LLC. So for a creditor to be listed on the BOI, it would be a question that you would have to check with a CPA or an attorney to figure out exactly the creditor status. An employee, just by nature of being employee, is not on the BOI. Of course, that doesn't include any of the employees that we talked about, which are C-level employees. And one of the conditions that an employee doesn't have to be on the BOI is if the employee gets salary. But if the employee has 25% shares, then the employee would have to be listed as beneficial ownership based on their share options. And a custodian nominee for one of the owners, for one of the beneficial owners, does not have to be listed, but obviously the person behind the custodian nominee would have to be listed. Okay, any questions? Okay.
All clear.
What information is required and what are the deadlines? So when you file a BOI, there's there are two sections to report. The first is information on the reporting company itself, and the second is on the beneficial owners. The reporting company, you would have to list the legal name of the reporting company, any trade name or DBA, the current street address or principal place of business, the jurisdiction of formation, which is the state, and the taxpayer identification number. So one of the questions that we get asked often is, let's say it's a single member LLC and there is no EIN, you can fill it in with your own tax information, which would be your Social Security number. Beneficial owners, again, the legal name, date of birth. You need your residential address. Now, this is very important to know because your residential address can be changed. And that means that you would have to, at that point, update your BOI. And the same thing with your personal ID. That can be a passport or driver's license number. Those numbers can change. And if they do change, then you would have to update your BOI. Not only do you have to write the number and the information on your ID, but you need to send in a copy of the ID itself. So what happens when you have an exempt entity? So let's say you have an LLC, that's a large operating company that owns a LLC that has to file the BOI. So the parent doesn't have to file the BOI, but the child company has to file the BOI. So let's look at this case. Let's say in this case, the reporting company, same case as before, you have a reporting company, but the owner of 50% of the stock is an exempt entity. Now you have individual A and individual B who own, individual A who owns 25% of this reporting company. Individual A does not have to report his name. The individual A will not be listed on the BOI. Instead, all the people standing behind the exempt entity, you would just list the exempt entity name and say that the entity is exempt, and that would protect all the people behind the entity from reporting their information in the BOI. What are the filing deadlines? So for any pre-2024 LLC, the filing deadline is January 1st, 2025, which means you still have about 5 months to file. I don't advise waiting until the last minute, especially if you have multiple entities. Any entity that was formed in 2024, you have 90 days to file from the date that the entity was registered with the state, which means that people, we've already filed many, many BOIs for companies that will form this year. And from 2025 going forward, it's 30 days. The rule was actually in 2024 supposed to be 30 days as well, because that's the time frame the government wants to see you file your BOIs. But because of all the confusion and because it was just starting out and the database wasn't completely working properly, so they gave a grace period of 90 days for 2024, but going forward, it's going to be the standard 30 days. There was a new FinCEN update last week, and this was, to me, it was shocking. Maybe other people thought differently. I don't know. Ellie might have argued. But the original thinking was, let's say I have an LLC and it was formed in 2023, and my deadline to file is December 31st, 2024. That means I thought that you can dissolve the entity this year because you're not required to file yet, and you don't have to file your BOI. But FinCEN says otherwise. FinCEN says no. As soon as January 1st came, you were required, you became a reporting company, and you were required to file your BOI. Even though we give you till the end of the year as a deadline, you're now required. And once you're required, you have to file a BOI whether you dissolve the company or not. So any LLC that existed on January 1st, 2024, even if they were subsequently dissolved, will still be required to file a BOI report at the end of the year for their dissolved entity. Any LLC that was formed in 2024, so if you form an entity today and you dissolve it tomorrow and you didn't reach your 90-day deadline, you still need to file the BOI. And once you formed, that's it. There's no turning back, and the BOI has to be filed. What about updated filings? Filings have to be updated. What could be the reasons for updating filing? Just remember, the BOIs have to be filed once and only once. You don't have to file it yearly. It's not an annual filing. It's a lifetime. But if things change, you have to update the filing. So if you add a new DBA, if you have a new beneficial owner, if you have a new decision maker. So if there's some change in ownership structure or the people involved, or you have a deceased beneficial owner, you have to remove them. Or if you have a child who's an owner and the child reaches majority, or if you have a beneficial owner that changes their address. So you can have a bunch of people on the BOI, and if just one person changes their address, you need to update that BOI. Or if somebody has a change in their ID number. If you end up with an inaccurate BOI, you made a mistake and it happens, you have to file within 30 days of becoming aware of your mistake, and you will not be penalized if you report it, if you correct it within 90 days. I don't know, Ellie, do you know what that means? I don't know what that means. It means you have to file within 30 days, but you won't be penalized if it's filed within 90 days. That's, I haven't figured out what that means. I guess I would do it within 30 days and not wait for the 90 days because we probably don't want to find out what that means. And if you're newly exempt, let's say you had an LLC, and congratulations, you now have grown to 20 employees and $5 million in sales, you need to update FinCEN that your company is now exempt. Now, this is very important that we suggest to all our clients. You don't have to go through every LLC and file all this information. If you have 10 LLCs, you don't have to go to the database and file this information 10 times. You can get yourself a FinCEN ID number. Once you have a FinCEN ID number, you can just drop it into every BOI report that you file for, if you're a BOI, not for the others. Everybody would have to have their own FinCEN ID. The beauty of that is that if you end up with 30, 100, 500 LLCs, and then you decided to change your residence, you don't have to go and update 500 LLCs. You just go and update your FinCEN ID, and then all the BOIs are still accurate because they all reference back to your FinCEN ID, which has now been updated. So that's very, very important. Even if you don't have a lot of LLCs, we highly advise that you get yourself a FinCEN ID. What are the penalties if you miss the deadline? So the penalties are quite severe. As you see, it's up to $500 a day for non-filing, which can be up to a maximum $10,000 plus 2 years in jail. The important thing to know here, the key is that it has to be willful intent. If it happens by accident, I don't know how easy that is to prove. I wouldn't play around with that. But if you actually did make a mistake and you, by mistake, didn't file, then you wouldn't get penalized according to the law. Okay, now we get to the interesting part. On March 1st of this year, there was a lawsuit against the CTA brought by plaintiffs, the National Small Business Association. And they said that it wasn't fair to make the small business owners file the BOI. They said it cost too much money, it was too invasive. And believe it or not, the court ruled for the people, and it said that the BOI, the CTA, was unconstitutional. Now, let's go dig a little bit deeper into the details over here because it makes a difference. First of all, this happened in the Northern District of Alabama. And the ruling said not that it's unconstitutional, but the effect of the ruling was that it can't be enforced against the plaintiffs. So aside from anybody who wasn't a member of that association, FinCEN says you all have to file. It's not going to help you. Now, what were the arguments in that case? What the judge said was that it was really a wipeout against the federal government, because there's two ways to argue this case. One way to argue is that the government does not have the power to enact the law, which should seemingly be very hard to say. And the second part is that, yes, the government can enact such a law, but it violates one of the constitutional amendments of the citizens. So the government tossed this case out, saying that the court threw the case out, saying that the government did not even have a right to enact the CTA. The three rights of the government that the government claimed it used to enact the CTA were to regulate commerce, interstate commerce, and this was important in order to make sure that commerce is fair, to oversee foreign affairs and national security. They claimed that this harms national security without them knowing the information because of the terrorist and drug money. And the third is to impose taxes. This information will be used by the IRS for tax evaders. So those were three very strong arguments for the government to be able to enact it. And the court, the judge, said no. What they did with the CTA is not a good enough justification even for these three things. It violated these three things, and they simply didn't have the power to enact the CTA. And that was quite a shocking ruling. The government right away went ahead and appealed, and it's still an appeal in the Alabama Court of Appeals in the 11th District. Now, there's another case, the Michigan case. The Michigan case was already heard. The court has not gave their decision, but unlike the first case, they didn't give a summary judgment because they believed that the government could have the powers. Without thinking about it, it wasn't so clear to them that the government didn't have the powers. But they're getting really to the meat of the matter. You have to understand that the NSBA could have filed their suit in any district in the country because they have members in every district. They chose the one district that was conservative enough that they thought that they could win the case. So it's not really a good example to think, okay, it was thrown out of court over there, the CTA is going to be overturned. It's not so. Let's see if it stands up to appeal. And certainly in more of the liberal states, the government should have no problem upholding their stance. But when we get to the Michigan case, we're looking at more of the core issues behind the CTA and the problems why it might not be constitutional, specifically the Fourth and Fifth Amendments. The Fourth Amendment protects people against unreasonable searches and seizures. So the government wants to come into your LLC and know exactly who's behind it. They want all the information. And the question is this reasonable or is it unreasonable? Reasonable search would be if we have a reason to assume that you are hiding criminal activity, but your typical LLC is not hiding criminal activity. So without any special reason, the plaintiffs argue that the government has no reason to take this information. And the same thing, the Fifth Amendment, the safeguards against self-incrimination and due process rights. The problem over here is that the laws are very vague, and therefore we don't know who really has to file, who doesn't have to file. It's not clear enough, and therefore it violates our Fifth Amendment rights. Now, the Fifth Amendment, they could probably fix up by clarifying the laws. They purposely left it vague for their own reasons, but there are ways that even if the case, a court rules against the government could just amend the law to fix it to satisfy the courts. So what's going to happen next? What's going to happen next is that there are going to be other lawsuits in other states. There's already one pending in Ohio and Maryland, and they'll be cropping up all over the United States. It's already gone to the Court of Appeals in the 11th Circuit. Now, Court of Appeals, the way it works is that Court of Appeals are not bound by one another. They have to look at the other ones, what they did, and take their judgment into account. But they don't have to rule according to them. They're not bound by them, which means that you could have different Court of Appeals ruling differently. So we're expecting, or the legal world is expecting, split rulings with regard to the Court of Appeals. And eventually this case may make it to the Supreme Court, which may end up being a very landmark decision as part of the government's powers to control commerce and satisfy the, and rule on this case for once and for all. So that's where we stand. It's hard to know where we stand. It's hard to believe that anybody, unless you're, you can check your local courts and see who's filing a case against the government. If you'll get relief this year, it's very, very hard to believe that you'll be spared from filing any BOIs that are due this year. You may get spared in the future, but this year we are advising our clients to just go on and file their BOIs because they won't see any relief in the near future. So just to give you a quick introduction now that we're wrapping it up, NUCO Filings. NUCO Filings is previously Riverside Filings. We're now an independent company doing the same service, same people. We're experts at assisting with LLCs and CTAs. We have an incredible portal that can manage not only the entities that you form and manage with us, you can use it yourself to manage your own entities, and we give it to our clients completely free. You can easily track and update your BOI reports. This is a big problem with filing with the federal government. When you file through the federal government's database, you can't track it. So like we've had people that asked us to file BOIs. We can't go into the government database and see if they filed already. So what ends up happening is we file it, and as soon as it's all finished and ready to go, we'll get an error message saying that there's a BOI already filed for this case. So what we do is we track your BOI reports. You'll know what's filed, what's not filed. And we have registered agent service in all 50 states, which means that we are a one-stop shop for all your formation needs. That wraps it up. And if there are any questions, I'll be happy to answer any questions. If you want to shoot me an email, you can send me questions on email. My email address is tweiser, that's TWEISER @nucofilings.com, NUCO filings.com. Be happy to hear from you. Be happy to hear any feedback. And thank you for participating. Have a great day.
Thank you, Tzvi. If you want to unmute, if anyone has any questions, maybe give everyone and some of the options.
Sure.
Okay, if anyone has any questions, if you want to speak up, if not, feel free to put it in the chat or send us an email, and we'll be glad to help out.
Thank you, everybody.